In this episode of Building the Case, we are going to be talking notice provisions in construction contracts. I am Brett Burney from Nextpoint, joined by Jerry Crawford, Principal Director at KGC Consulting, who provides expert services in construction dispute litigation support. Jerry, can you briefly explain what a notice provision is, why they are important, and how common they are in construction contracts today?
Yes, thank you, Brett, for the introduction and notice provisions. They're very important aspects to have in the terms and conditions when disputes and issues arise. It's common for construction contracts to impose notice requirements on parties seeking to make claims in relation to the contract. And these clauses usually impose strict and often multiple timelines on claimants and state that a failure to comply with the timelines will invalidate any claim to an extension of time or money or both.
Okay, thank you. So then what are some of the triggers, Jerry, that lead up to advancing a written contract notice then?
Yeah, there's a host of triggers. I'll cover just a few for the sake of the audience. Where there's a contract being issued, but there's no building permit, so the contractor's not in a position to proceed. You could have unforeseen ground conditions, cobbles or archaeological artifact discoveries that have to dictate the project has to suspend operations. An unresolved RFI or request for information that could imperil the schedule or is imperiling the schedule. Request for an extension of time due to severe weather, a delay in receiving owner-supplied equipment. A contractor realizes he's not going to be able to execute the critical path properly. A failure in user groups to sign off on certain scopes of work, such as data cabling. Rework could trigger a notice provision. And the subcontractor's inability to execute his scope of work due to previous bad workmanship by others he has to connect into.
Like you said, there's a collection there of some good triggers, but thank you for giving some good examples there. So then maybe let's get down to a little bit more of the practical approach, maybe the logistics of how should notices be drafted? What do maybe they look like a little bit? And then of course we want to make sure that they are valid. So how can they be served in order to make sure that they are valid?
Sure. So I assume we're talking about delay notices impacting the schedule and or the budget or both. Notices must be in writing and delivered within a specified time limit identified in the contract. They have to be served in writing to a specified designated party. The notifying party should give notice as soon as possible when a known event will impact the budget cost or schedule performance. A description of the anticipated effects, including time or cost impact. A reference to the notice delay contract clause referencing the drawing and specification is helpful. Include a photograph with good footnotes of the impacted area or the areas is extremely valuable. And that pretty much covers a lot of the basics that I would recommend in preparing a good notice provision.
And then, like you said, that's really more for like delay impact events, right? What you were just covering there. Are there some other maybe examples where you've seen notices issued other than for delay impact events?
That's an excellent question. At KGC, we advise our clients to issue a notice to mobilize 2 weeks in advance. Describe and reference the subcontract, the schedule, emphasize the date commitments that you're obligated to, emphasize how much material is arriving and the size of the crew and equipment arriving. So you're being proactive, ask in the notice if there are any special logistic requirements for unloading, but more importantly, stress to whoever you're drafting that notice to, if there's a problem with that mobilization date, please advise us in writing 5 days earlier. So we can reprioritize our schedule commitments, our logistic commitments, our vendor commitments. So often we see a blizzard of emails. Time is lost from day one up front with little or poor documentation. So the mobilization notice can position the contractor or the subcontractor for a delay claim later if it comes down to that. But it's good to be proactive. In another example, I'm a firm believer in issuing notices of non-payment. Use discretion. Maybe it's 31 days or 46 days is the unacceptable timeline for payment. Call the paymaster by telephone first. There may be a problem with the invoice that was issued. Describe the invoice in the notice. Attach a copy of the invoice. Identify the time or working days to make good on the payment of the invoice. And then advise the paymaster non-payment constitutes a material breach of the contract. Inform that you are probably going to seek recovery of interest as well for non-payment. Other examples, you could have change of additional work, notice of multiple problems, directed acceleration on the schedule. So notices can be used in a very proactive manner as well as a reactive manner.
And frankly, it just sounds like these are some good ways to avoid risk, right? Ultimately, whatever that may be, and typically from an expense aspect. But maybe what are some of the other risks area where maybe notices could be used? We're talking about delay impact notices or cost impact notices, and often maybe they're not used. They're unfortunately they're not listening to you, Jerry. They're not being proactive on this. Why is it sometimes that they just don't happen or they're not included when they should be?
Yeah, from our observations, we generally find the problem is bigger with the smaller general contractors and the subcontractors. Quite often, these stakeholders may be working for a private commercial interest. They fear repercussions if they serve notices in writing. They have additional costs or delays, possibly being delisted from bidding on future work is a concern. Often these firms, they do not have contract savvy individuals that are indifferent to following the contract terms and conditions. Many projects are administered by engineers or individuals with an architectural design community background that have no academic appreciation or training in contract law, indifferent to the fact they have entered into a contract with specific written obligations. Many change orders do not have a reference to a time impact adjustment. Another failing is reliance on the meeting minutes and hazy, vague email exchanges about the problem that is not really fully crystallized properly. At KGC, we see a lot of fictional outcome-based bias thinking that my project problems will magically get better and they will recover the lost schedule time. Then there's the verbal assurances that are pro-offered. We will take care of you at the end of the project. That seldom happens. Even in 2026, a number of contracts that are getting done on verbal agreement handshakes far too often on good faith understanding with no thought to the situation could get tricky later. We see a lot of this behavior in high-end custom home projects. Just, they don't want to face the reality of what they're dealing with.
But the alternative is to that is to face a reality whether you want to or not, if you don't choose to be a little proactive in this. This has been fantastic, Jerry, and thank you for sharing all of this information. How about maybe just a couple of takeaways at the very end here? Any other closing thoughts about notices?
Yes, indeed. Read and follow your contract. I cannot stress that enough. And remind the other party, we are just following the obligations under the contract terms. We're not looking to pick a fight here. We're just following what's the agreement understanding between us in writing in the contract.
Jerry, as always, it's great to hear from you and to just listen to you share some of your knowledge in this important component. Jerry Crawford is at KGC Consulting, which is at kgcconsulting.ca. You can go and get a lot more information about his services there. And we thank you as always for joining us, Jerry. Thank you.